I'm delighted to introduce Professors Andrew Keay and Joan Loughrey from the School of Law at the University of Leeds, who are here to talk about a topic which some of us, if you're an MCL student, will have been working on related stuff this week, but it's something that will be of interest to all of us, I think, which is directors' business judgments, and in particular the question, should judges review directors' business judgments? So I'll hand over to Joan to begin.
Okay, so the topic of the talk is, as Mark said, should judges review directors' business judgments? And this is actually based on a qualitative work, interviews that we've been carrying out with directors, company secretaries, general counsel and legal advisors. It comes out of an arts and humanities research council-funded project that began in October 2016. It finished at the end of November 2018, but the outputs from the research are going to be coming out for some time to come. The team in this project is an interdisciplinary team. There's myself at the School of Law at Leeds, Professor Andrew Keay, who's also in the School of Law. We had a research assistant, Dr. Francis Akanabone, who is currently at Liverpool, John Moores, who's also a lawyer. But we also had two colleagues from the Management School at Liverpool, Professor Terry McNulty and Miss Abigail Stewart. Now, the goals of the project, we had a number of research questions, but they can boil down into three research questions, three main ones. We wanted to look at what was meant by business judgment, how the courts apply business judgment, and should directors' decisions be subject to review by the courts. Now, in relation to the first question, Andrew Keay and my article on the concept of business judgment has just been published by Legal Studies in their most recent edition. It took quite a long time for that article to come to press. It's like publishing hiccups. The second article to how do the courts actually approach reviewing directors' business judgment is out for review, and the one I'm going to be concentrating on today is the third one. So just to give you, at this point there will be a slide going up saying this is the structure of the talk today. So I'll just explain, I'll be saying a little bit about the context, what research questions we're going to be answering today, why we think the approach we've adopted is important, talking a little bit about the methodology, and then I'll hand over to Andrew, who hopefully by that stage we will have the slides, because he'll be talking about the academic arguments for review, but certainly hopefully the slides to present our findings to you, and then I will finish with some conclusions. Now, the context of the paper is the ongoing concern with director accountability for business decisions. And we saw this concern with director accountability really come to the fore in the wake of the financial crisis, and concerns about the lack of accountability of bank directors for the way in which they had managed the banks. And the concern hasn't actually gone away. It's stayed there because of events that have taken place actually during the course of the project. Perhaps the most notable is the collapse of Carillion. And in its review of annual review of corporate governance, Grant Thornton in 2018 said that the UK is witnessing a battle to restore trust in business. Governance is more in the spotlight than in the Maxwell years. Now, those of you who were around in the Maxwell years, which makes about three of us, I think, will know that the problem with Maxwell was problems of fraud, where Robert Maxwell basically looted the pension funds of a group of pensioners called the Mirror Group of Pensioners before he came to untimely end. There is a material difference between the Maxwell years and now. It's captured by a Financial Times headline, which you would see, Carillion's board misguided or incompetent. What we're concerned, now a lot of criticism has come at Carillion directors, but what it seems to be really about is that they were incompetent, possibly recklessly incompetent, but incompetent in relation to the business decisions they took. So reading the report, much of what they're criticised for, you read things like the directors allowed Carillion to knowingly enter risky markets in the Middle East, that the directors are criticised for the business model, for allowing a practice of late payment of invoices in relation to small suppliers, in relation to decisions to pay dividends and so forth. And arguably, a lot of these are business judgments. And this raises the question, looking at public anger focused at Leeds directors, is should directors' business judgments that have adverse outcomes be subject to review and directors be subject to liability for them whenever they are arguably incompetent. Now, there's lots of arguments in the literature, in the academic literature, that says that it's not a good idea to hold directors to account for these judgments, and Andrew will be canvassing some of these shortly. But we wanted to explore this issue from a novel perspective. We wanted to speak to the people who are at the coalface, so the people who are the actors in the process. So we want to speak to directors, company secretaries and their legal advisors to see what views they had of the prospect of judicial review and liability for business judgments. We wanted to ascertain or try to check to what extent these views were consonant with empirical assumptions that you find about the impact of review on directors that you see cited in the academic literature, and also to assess to what extent directors and co-sex views and so forth about the desirability of review were based on their own normative positions. So, why is this important? Why are directors' views, why are the views of these actors important? Well, from the perspective of the academic literature does not always make clear the extent to which arguments against review of directors' decisions are based on positive empirical claims and the extent to which they're actually normative in nature. In fact, given the lack of robust empirical evidence in this area, one might think that the weight attached to empirical claims about the impact of review actually reflect a prior normative position that the commentator has about the desirability of review. So, for example, if someone was more pro-review of directors, wanted to see more accountability, they might, for example, downplay the risk of directors being deterred from taking positions as a result of review, whereas someone disposed against review might give that risk far more weight. But insofar as these arguments against deferral do depend on empirical claims about the impact or process of review on directors, then clearly directors' voice in these matters must carry particular weight because it's them. It affects them directly. So if directors don't report that they will behave in accordance with these predictions, this weakens the arguments against review based on the empirical claims, but doesn't undermine them. Our research is qualitative, so the usual caveats about qualitative research apply. It's not generalisable and so forth. But even so, they don't express these reviews, or not as consistently as one might expect. This does challenge some taken for granted assumptions. On the other hand, if they do clearly express these views, then this strengthens the arguments against review, albeit with the caveat that the director's responses might be coloured by self-serving bias. So the first question, do directors display the attitudes that the literature predicts? From the point of view then of some of the directors and co-sex that we represented, we interviewed, they were situated in FTSE 100, FTSE 350 companies. They are the elite, and the views from the point of view of their normative views about the desirability of review is also important. Why? Because these are influential actors. They exercise instrumental power over the policy-making process. They can use political channels and resources to affect policy change or indeed to resist policy change. Now, this influence can be apparent if you take a look at the responses to many consultations on corporate governance. You see that the majority of the responses come from trade associations, come from business, come from general counsel, co-sex and so forth, and also from individual businesses. And I suspect that if we review the outcome of consultations, we would find that the approach that the government adopted to which measures it adopted by way of reform would be more in line with the views of business than not. But it can also be latent, and it can also happen behind the scenes. And in the course of our interviews, we interviewed one co-sec in a FTSE 100 company. And I'll just read out the quote, if you forgive me. He said that when we designed, and this was somebody who wasn't on the Company Law Review Steering Group, that was the group that was responsible, that put forward the reform proposals. And he said that when we designed the Companies Act 2006, so that there was a possible right to bring a derivative action rather than relying on exceptions to the rule. There was a real worry that there would be a plethora of US attorneys coming over. So that was why the two-stage approach was put into the Companies Act. So you may know that in order for a shareholder to bring a derivative action in the UK, they must go through a permission process from the courts. It's a two-stage permission process. So that was why the two-stage approach was put into the Companies Act, to make sure that there were no frivolous claims being brought against directors. We sat with officials and put all that in. Now maybe that has worked too well. Now, and I say this person was not part of the Company Law Review Steering Group. Now here we see direct influence shaping the level of accountability of directors in the courts. And indeed, it was quite effective. The levels of derivative action remained low, and there's not many cases that have actually got through the permission stage. But we didn't just interview directors of the elite firms. We also interviewed directors of unlisted public companies, private companies, and owner-managers. And these directors are far more likely to face judicial scrutiny for their business judgments through disqualifications than directors of elite public companies, who are practically never going to face that. And they will normally face it through disqualification. And indeed, disqualification remains the weapon of choice, it seems, by policymakers for holding directors to account in the courts. We saw this with the Small Business and Enterprise Reform Act in 2015, which brought in reforms to the disqualification regime. And we see it in the government's latest corporate governance and insolvency proposals. The government has proposed that a director of a holding company who doesn't give due consideration to the interests of stakeholders, a financially distressed subsidiary, may be subject to disqualification. Now, how is disqualification meant to work? Well, there's a Court of Appeal decision, Blackspur PLC, where the court said that the way the Act is going to work, the way the Act is going to protect the public, because that's the goal of disqualification, is by means of prohibitory remedial action, anticipated deterrent effect on further misconduct, and encouraging higher standards of honesty and diligence. They want to focus on encouraging higher standards of honesty and diligence. The Act is meant to have, disqualification proceedings are meant to have an educative effect. Whenever directors come to court, the courts get the chance to articulate standards that directors will be expected to adhere to. And this potential for the law to have an educated effect has been recognised by other writers. Rock, in his seminal article, Saints and Sinners, How Does Corporate Law Work, said that the law can have an educated effect even without liability. But given this purpose of the law, it's important to understand the views of the directors who are vulnerable to review, to the prospect of such review. Why? Because the literature on law and social norms suggests that if directors do not consider judicial review of the competence of their decisions to be legitimate, the judgment of the courts will not have the desired educative effect. And on the contrary, the literature on accountability suggests that directors will become more entrenched to decisions they have made for which they're held accountable afterwards. And this effect could be exacerbated if they don't see that process of review as legitimate. Finally, what directors think and COSECs think and so forth about directors' decision, about review of directors' judgment by the courts is important to judicial practice. One might expect that understandings that the impact of review would be detrimental to directors could have an impact on the practice of the courts, that judges would be concerned about this. Again, judges' assumptions about the business community's understanding of the appropriate role for the courts and the legitimacy of review could also be influential. Judges are presumably concerned about doing justice, and the views of the business community about whether review is just could be of at the very least, of interest. And of course, judges are influenced by academic writing. They don't always cite us, as we know, but they do read us. And insofar as judges are relying on academic arguments that are based on these empirical assumptions that may be wrong, or may be shown to be right, or more likely to be right, I should say, then the weight that judges attach to those arguments may vary. Now, judges will not be UK judges will not openly acknowledge paying attention to these issues, paying attention to what directors and COSECs think, but it's likely to be latent. Kershaw said in a recent book, judges cannot divorce components of their personality formed by strong societal and political consensus from their judging experience. These form their taken for granted expectations, both of the directorial role and the accountability function of corporate law and regulation, and they take these taken for granted assumptions into the court and into their judging. Now I'm going to just say a little bit about the methodology here. We conducted semi-structured interviews and focus groups that involved directors, co-secs, 2 investor groups and legal practitioners who had advised directors. In the interviews and focus groups we used questions, but we also used case studies. I'll explain the use of case studies in a minute. The case studies were based on actual cases that have been decided by the courts both in England and Wales and in Australia and in one instance in the US. Case studies weren't always used in the focus groups. If the focus groups were very large, they were not going to be workable, too many people talking. We tended to use questions there. The interviews and focus groups took place between August 2017 and August 2018. There were 9 focus groups. We had 4 with directors, 1 with chairs separate, 4 with co-secs and counsel. We also had 28 interviews, individual interviews with directors, as well as interviews with some co-secs and with the lawyers, including those with experience of the US and Australia, because we wanted to interview directors with international experience, because we wanted their perspectives on the different impacts of different judicial systems on directors and their decision making, the different prospects for review in different jurisdictions. So in the US, as you probably know, very well developed business judgment rule, very high degree of protection for directors. How did they feel that compared how did they feel that impacted them compared to their position in the UK? In Australia, there is also business judgment rule, a statutory business judgment rule, but there's a very proactive corporate regulator who has been prepared to take public company directors to court for breach of their duty of care. So we did want to get that comparative perspective. At this point, I would put a bunch of figures up showing you what who we interviewed. So I'll just say very quickly, FTSE 100 directors, FTSE 350, other public company directors. Private company directors did form most directors, we had 23 of them. We had 14 FTSE 100 company secretaries and 4 outside that 350. We interviewed a mix of NEDs, execs, chairs. We interviewed people who worked in financial services and other regulated industries, and people who worked outside the regulated sector, and as I say, 7 legal practitioners. And very quickly, just what the I'm covering for you.
Joan, could I interrupt a minute?
Yes.
I'm so sorry. Could you log into your...
Yeah.
Just in case it triggers the screen. Most of the IT team are at lunch.
You get that for doing
Perfect timing. But
I do on the website. Because normally it needs both screens, so sometimes it might recognise it.
There you are.
I'll find this. Sure. That's brilliant. Thank you. Thanks very much. Thanks.
I don't need the slide to just tell you about the case study, so I'll just keep talking. See if
Sure.
I can multitask. So the just call it up in the memory stick. So the purpose of the case studies originally was to really test the views of our interviewees of what they thought about the court's reviewing judgment in a range of key circumstances. What did they think about the court's reviewing monitoring decisions? What do they think about the court's reviewing decisions about how much you should rely on somebody, when you should seek advice, financial reporting decisions, and straightforward transaction decisions to acquire a company, pension contributions and so forth. But we always had the idea of using case studies. I'll get it now.
Sorry.
We always had the idea of using case studies. Okay, so that's not there. No.
It's not your day.
It's fine. But we ended up having to do it because what we found was we wanted to ask people about business judgment, but the concept of business judgment has no salience in a business context. Directors don't know what a business judgment is. It's not a term that's used in the literature. We also found actually that the UK lawyers had no real understanding or concept of what a business judgment is. So we used the case study to ask them whether they thought any of these things were business judgments, and just to pin down the discussion. Let's see, Andrew, do you want to come through? And I'm going to hand over to Andrew now, who has just escaped the... That by the way, are the figures on our interviewees, but I might put it up at the end if I've got time. Okay.
Well, I've got it easy after that. Takes me back to the old days when we didn't have slides and we used to rely on overhead transparencies. I remember the days when I was at university when there was nothing. Okay. There's a lot of arguments against directors' decisions being reviewed by the courts, and I'm not going to purport to deal with all of them because it would be impossible in the time that we've been allotted. But I'm just going to deal with some of them, and then I'm going to look at some findings that we got from the interviews and focus groups as to what directors and other people were saying. First of all, as you can see, one particular argument is that engaging in reviews by courts will deter directors from engaging in risk-taking. Directors are sort of said will be concerned about looking over their shoulder to see who's looking at what they're doing, and that will lead to a cautious approach. Goodness me, we won't do this because this could be subject to some sort of review later on, so we'll keep back from aggressive strategies. And it's said that essentially if you have review, then directors will in fact be more, as I say, cautious and will fail to maximise wealth for the benefit of the shareholders. It's been said that, it follows on from that will discourage managerial risk-taking, and directors will not move into new markets and be innovative and adopt particular business risks because of fear of being subject to review at some stage in the future. It might be stifle directors' pursuits. It may be such that in some ways lucrative opportunities might be missed because they're too risky. Now, directors of large public and private companies often don't have shares in the company, and so they've got no direct benefit from the risk-taking, it might be said, so they're not going to take those risks. So they're going to say, well, I'm not going to engage in those sort of things because in the end I could be subject to some sort of review and I'm not going to get any benefit out of it. So that was one of the first arguments that's used against review. A second one is judges lack experience and ability. Judges are not business experts, as a number of commentators have said. And this is acknowledged by the courts, and I just mentioned a couple of American cases there on the slide. Directors lack an intangible sense of the circumstances that exist when directors have to make decisions. And the noted contractarian scholar Daniel Fishel has said, courts do not possess the experience, expertise or information necessary to make complicated business decisions. So it's possible that judges, in reviewing business decisions, so the argument goes, will sometimes get it wrong in determining how and why directors are in fact wrong. And Stephen Bainbridge has said that most judges are likely to arrive... We've got the right... No, we haven't got the right one. Have I gone too far? Yes, there we go. It's working still. Yep. I hope you can read those. It's small, isn't it? Okay, well, it's better than what we had before anyway. Stephen Bainbridge has said most judges are likely to arrive on the bench will have little experience or expertise in corporate law and equally likely have little incentive to develop substantial institutional expertise in this area after they arrive. Well, maybe the Delaware Court of Chancery might disagree with that particular view, but of course he's talking very generally in that particular context. And the argument goes, well, judges are going to have access to disclosure that's taken place before the litigation gets to court. They will have basically exposure to the evidence in court, and therefore they're going to know a lot more than the directors did when they were in a position to make their decision perhaps many years before this actually gets to court. And actually Bainbridge even argues that judges will actually shirk in making their decision on directors' responsibilities and decisions, and they will make a decision based upon minimal effort, embrace shortcuts, and I'll come back to this particular argument a bit later on. So decisions by directors may in fact lead to bad results, but sometimes those bad results may have occurred anyway, so the argument goes. So that in allowing judges to make decisions just isn't reasonable and fair in the circumstances. Now, perhaps allied to that is another separate argument, and this is a major argument that's put forward for directors' decisions not being, in fact, reviewed, is the hindsight bias of judges. Now, hindsight bias, according to Steve Bainbridge, is the tendency to assign an erroneously high probability of occurrence to a probabilistic event simply because it ended up occurring. So the argument is, of course, that persons who know the outcome of something are often going to think, well, it's going to occur anyway, and didn't they just see it? Couldn't they have actually seen it and made basically an adjustment to their decision? So judges will hear cases about the judgments of directors well after the judgments, of course, occurred, and this will permit them to have a better view of what the decision was all about and the consequences that resulted from that particular judgment. So the view is that judges will see and perhaps see the consequences as something that would have normally occurred, and the effects could have been basically seen at the time of the judgment. And in some ways this might be heightened in insolvency cases. So in many cases against directors, they're brought by liquidators and the company's gone into insolvency, and judges might be more concerned about making a decision about what directors have done when there's been catastrophic results from possibly the decisions directors have made. In an English decision, Reliving Images, I think it was Mr. Justice Laddie said that judges analyse decisions in the, to use his words, the clinical atmosphere of the courtroom, and it's easier to see signals that are basically available to the directors, so the judge might think when hearing the case, and assume that the competent director would have seen this occurring, or should have seen this occurring, right from the get-go. So judges see bad decisions of directors ex post, and they may regard outcomes as foreseeable. There are cases, and I've mentioned a couple on the slide there, where judges are clearly alive to this concern about the hindsight bias. And in the case of Rees Sherville and Associates Limited, the court said what has in fact happened was always bound to happen and was apparent. That's going to be the concern that any judge should take into account. So those are some of the arguments that are used for non-review. Some of the findings, and these are just some preliminary findings that we've taken from our interviews, there is some support from directors that there are risk-averse consequences, that they feel that if they were to be reviewed, then there would be more caution in what they did. There is division over this, though. Some, in fact, thought it was a good thing to have review, and others didn't think it was a good thing. The ones who didn't think it was a good thing actually said some of the things that the arguments I've already put forward said. that it would stifle innovation and value creation and so forth and so on, slow things up, it would be disruptive for the company and so forth, and may even paralyse it. But in fact, most had not experienced any review themselves, or even knew people that had been subject to having their decisions reviewed. And their main complaints about review was in relation to financial services regulators. They were quite vociferous about the financial service regulators, and also the media, who they saw, particularly the Daily Mail, as being extremely critical of what they did. I can't think why. The Daily Mail is extremely well balanced. But some thought that risk aversion could in fact be positive. Some thought that it would lead to better informed decisions, carefully thought through decisions. One UK director who in fact had been subject to legal accountability had said that it led him to be more questioning, more rigorous and cautious, and slightly less trusting in what people told him or what he was doing. And it encouraged longer term thinking and focused directors' minds on what the consequences of the decisions would in fact be. And they, again, as I said already, referred to the regulators and media and also activist shareholders as being more of a concern to them, the courts, who really, they sort of saw the courts as rather remote, and no one really had very much experience of the courts, and really would not say, many of them, that review would be bad or in fact good. Excuse me. And in fact, some thought that it would in fact be better to have more judicial review and scrutiny, as that would enable directors to have their minds concentrated on what in fact was their interest and what was in fact the company's interest, and the fact the two were not overlapping or actually the same. One Australian director said that he felt that Australian boards were more conservative in their decision making these days because of the fact that there'd been a number of judicial reviews of actions of directors. The Australian regulator has been quite aggressive in relation to public company directors in the past. I've gone too far again. Where are we? Okay. We've got our slides mixed up here, Joan. Have I got up to that? Yeah, I'll go on to the impact on directors personally and professionally, because time's getting away. As far as the impact on them in this perspective, some directors felt that there was greater scrutiny of directors' decisions could deter them from assuming positions. But there was basically a perceived lack of scrutiny by the courts. As I said, they tend to be regarded as being remote from the directors. And really what they were saying about their views was more a prediction than actual experience. And as I've already indicated, they were more concerned about the review of what they were doing by the financial services regulator and the personal accountability of the senior managers regime than particularly the courts. So there was a feeling that greater scrutiny could in fact deter directors from making decisions and also assuming positions. But in fact, the data that we have basically got suggests that directors were leaving a particular sector, like particularly the financial services sector, because of the fact that they were concerned about the scrutiny of the financial services regulator, and they weren't abandoning the role of director totally, they were just moving into another sector. And they often saying they were leaving or were thinking about leaving because of the fact that they were, in fact, not getting the same job satisfaction from their work, rather than being really concerned about review by the courts. And in fact, certainly some non-executive directors were saying that job satisfaction kept them in the job. They found it something that was good, and despite discouraging criticism, particularly in the media, they were happy to continue. So we thought that job satisfaction was possibly a significant determinant of whether or not directors, in fact, were willing to enter or indeed consider maintaining their role as directors. Now, I need to cut this a bit shorter because of time, because of we need to move on. If I can possibly just move on to the next set of findings, which is in relation to judicial limitations. Despite the fact that, as I've already said, directors have had no experience of the courts and have not, in fact, been subject to some sort of civil or criminal actions, they, or at least some of them, did sort of communicate some of the same thoughts that academics had communicated on the basis of judges just are limited in this role. They have severe limitations. We ask, but how do they, in fact, know that? And perhaps the answer is they've been told that by the company secretaries, legal counsel, and outside lawyers, and in fact advise them. And this might perpetuate, in fact, the arguments that have been put forward in the academic literature, rather than, based upon the, in fact, experience of the directors involved. So arguably, the reservations they have might be, in fact, post hoc justifications for a prior normative position that's been taken, rather than, in fact, their experience then making a determination for them. So if that's the case, then that is obviously somewhat of a concern. There were three things that they indicated they were concerned about in relation to the courts, those directors that did pass a view on this. First of all, they said the courts lacked business knowledge, and only a few in that respect. Second, they lacked business acumen, and thirdly, the courts were unable to place themselves in the position of the directors. And this is where a lot of people that we interviewed made comment. They didn't think that the judges would have the subjective mindset that you would expect of a director, and judges weren't business savvy. They just didn't have the right disposition to be able to, in fact, make a decision about whether or not directors had acted properly in making the decision that they made previously and was subject to challenge. The fact is that we've sort of postulated that this might not in fact be a knowledge issue, but more of, because the fact is that directors don't have to have a particular knowledge or a skill set. They, in fact, directors, really it's risk-taking. It's probably at the back of this. Judges will not understand the risks, so it could be argued that directors have to take, it is argued, to make decisions. And this, in fact, might be linked to something we've argued for, which is that directors are, in fact, entrepreneurial risk-takers. And the argument is, or could be put, that judges can't emulate that. The most frequent reservation shared by the directors was, in fact, this idea that judges can't put themselves in the place of directors. And this is linked to basically the hindsight bias that I've mentioned already. One owner-manager said, quote, "If you were the judge, how can you or anybody actually define how it felt at the very time that the decision was made? It's the environment that you're in at that time, which I don't think any draft minute or transcript could ever define." And this leads us to the question of whether or not the decisions and judgments of directors are different from those of other professionals, if you want to call directors professionals, such as doctors. Is it a different issue? Hindsight was a concern across the respondent groups that we looked at, directors, COSECs and legal counsel. One director said, now a lot of things that happen in corporations actually take months or years to mature, and you can't necessarily see at a moment in time all the connections. And then what happens is the weeds actually grow to become huge, ugly things. Then everyone is saying, wasn't that obvious? Didn't you see that happening? And then one non-executive director thought that judges might be rather selective in the evidence that they took to fit in the view that they wanted to actually give in their judgment. That might even, in fact, chime with the Bainbridge argument that judges might shirk what they do. Okay, I'll finish there because of the fact that we're time short. Joan's going to say a few concluding remarks.
I might not actually.
Oh, okay.
Is it okay if we leave time for questions?
Sure, absolutely, yeah.
I suppose what I'd say is what we find that in terms of the legitimacy of review, just to finish off, we find that many directors were happy with the idea of review in some circumstances, and not just review of, in cases of conflict of interest, they were really happy with it. In cases where there was a failure process, they were far more disposed to it. But it wasn't just that. There was a feeling that the courts should look at decisions that have very significant impacts, and significant impacts could be the range of people, the numbers of people who were impacted. It could be the degree of harm. So if the harm was non-economic, they were far happier with the idea of review. Also review in the context of insolvency, and to a lesser extent, accruing not this study was going on in the context of where pensions were an issue. But I think the thing to really be aware of is they wanted review, not because they thought the other directors should be hung out to dry, although there was one person who said it would be helpful if they were. Actually, occasionally when things go wrong, it would be helpful if somebody is hung to teach the others. And I think that you might say help in what way, and who are you talking to? And what was very clear from our interviews that directors were very conscious of the public criticism and the public scrutiny that there has been of business. And there was this feeling that it was important that the director community should not be seen to be unaccountable. Saying that, although they supported the idea of review, they did not necessarily expect that review would lead to liability. They saw review in the courts as a means for directors also to explain themselves and justify themselves. So it's the process of accountability and review that didn't necessarily lead to liability.
Excellent. Thanks very much, Joan and Andrew. Questions, please, or comments? Don't be shy. Felix.
Just two short questions. One would be that there might be different optimal levels of risk-taking depending on the firm characteristics. So you might have, let's say, a non-neutral risk approach by the shareholders, so they're not diversified, so they actually do care about risk, which may then lead the directors to a more conservative approach, whereas there might be highly diversified shareholders happy with kind of risk neutral. And that of course plays a major role for the desirability of risk in that firm, and also speaking of the bias that the directors have when answering your questions. So my first question would be: is that something that is worth looking into, or do you correlate firm characteristics with the answers the directors gave? And then the second would be more kind of conceptual issues. The argument that courts are not experts is an argument in many other circumstances we don't accept, and we just say, well, then you can appoint an expert, and I guess we could find experts. And so I just wondered how you factor that into your research.
Yeah, take the second one first. We did actually run that past. Can we say we actually reviewed without saying anything about it? No. Okay. One part of the research that we've done is subject to the motor embargo, which we can't talk about. I can't explain why. So it sounds mysterious, I know, but I used to take my good faith in the moment.
Because the explanation would bore us.
No.
It's like one of these super injunctions, you know. So,
Yeah. But we did actually raise that, and generally speaking, people thought that it probably wouldn't work with experts because of the fact that every situation is different and every director is going to be different. Although, you know, you can see experts being used in some cases. In fact, in the decision of Asic and Rich, the Australian decision, there was in fact a chairman who'd been a chairman for many years and gave expert evidence. So it has happened in the courts, but generally people didn't think that was all that helpful. Although I sort of, excuse me, I think your question's really right, because I sort of thought about that too. We both thought of that. The first question about
we
that was really
we haven't correlated. I don't think the sample size is big enough to draw any sound sort of safety conclusions from that. What we have done is try and get a spread. So we will, in the papers development, we will highlight maybe when somebody's from the financial services sector, for example, because I do think that is important. Just to go back to the expertise aspect, yeah, you're right. What was interesting, I think, from the empirical results is the lack of judicial knowledge about business was actually the least common objection to the courts. The two most common objections were you don't have the mindset, which isn't about knowledge, it's about disposition, which is something that you can't capture, I think, with expert evidence. And the other aspect was, just not being able to be there in the flow of this moment and replicate that moment in court, which again, I think, is hard. It's not so easy to capture in expert evidence. Yeah. But no, we didn't correlate for reasons I said.
Thank you very much for your really interesting talk and explanation of the empirical data. I have two questions. One is, what consequences do you draw from the part that you presented us today? Maybe it's a bit interlinked with the question before, like would you, as a consequence, then draw that there should be less strict rules, or there should be more like rules forbidding the review, or would you just say, well, then we might need like another jurisdiction, lay judges on the courts, which would be from the business community, or so what consequences do you draw from this? As we see, we see the problem where the issue that businessmen have, and this regard business directors have, but what consequences could you draw?
I mean, the consequences are a different paper, because there's a whole lot of normative arguments that need to be engaged with as well in relation to review. What I would say is that if we're relying on empirical arguments, the data it's not clearly bad to review directors' decisions. There is evidence that directors review by the courts as a legitimate mechanism. Deterring risk the data is that risk will be deterred. You'll be deterred from taking risks, but it's not necessarily a bad thing. It's really to maybe move away from some of the empirical stuff, or at least acknowledge that the weight that you're placing on the empirical stuff might actually be informed by a normative position. Let's get the normative arguments into the open, and also inform policymakers actually and judges, so it can impact on.
Yeah, what we were trying to do was basically just present what was, the views, and analyse those views that exist.
Definitely.
And how they may impact on the normative arguments. Probably the intention was not at this point to make that definitive decision, but that's something that we bring together with some of the normative arguments, but also some of the positive research that we've done on the cases. For example, what have the judges actually said in this regard, which we've analysed elsewhere, and we'd like to sort of pull it together, which I think we've got to do at some stage to come up with something. I think on the idea of the lay judges, I mean, in England and Wales, that's just not going to happen.
I know it's highly criticized, or like, but I was just wondering, like, because this is really interesting, and just the consequences.
It was suggested by the directors that we could have a tribunal system, and with a director on the board or a business expert. Yeah, that's been put forward as a suggestion.
Yeah. It's not a crazy. I'm not suggesting your question was crazy. It's not. It's a good question. It's just that let's be realistic. What our judicial is.
And I think in the system where they're implemented, there's a lot of skepticism against lay judges at the same time. So it's like,
they're always going to be
exactly.
one way or the other. Yeah.
I think we could probably squeeze in one more question. Bobby?
Yeah, thanks for the talk as well. When you were speaking to the directors and the constituents you were interviewing, was the understanding that this would come towards the courts or it would be reviewed by judges in the usual manner, so a shareholder derivative claim, or were you thinking of something a bit more radical in terms of how it would actually get to the courts?
Well, I don't know whether we had anything in particular in mind. We wanted to try and keep it as neutral as possible, I think. But I think that obviously one of the things we were thinking of, the possibility of an action under Section 174, the duty of care provision in the Companies Act, being brought by a liquidator. That's one thing we were thinking of. But we weren't really particularly focusing upon any particular possible accountability mechanism. That was at the back of our minds, but we didn't float that. The actual scenarios that we put before people did in fact deal with issues that related to those type of questions, though. And when we asked for their view, we actually set these out before them and said, do you think this is a business judgment given by this director in this context, using some of the cases that have been dealt with on different types of causes of action?
So it's interesting, I think, when you mentioned how it could be a deterrent to people joining boards, that's usually in the context of public company boards, because if you're a private company, you're the owner of the company itself, or you're there as part of a closely held company, whereas you don't really have much of an option, you're going to be on the board, whereas for a public company, that's when the deterrence aspect comes in.
Yeah.
And if it's just shareholders, though, really, or liquidators that have the option of putting this to judicial review, there's very little chance, it happens so little that it comes up, goes to court, so whether it really is a deterrent, well, I'm not sure.
Well, that was the other thing, of course, because most actions, as you probably know, that are against private company directors. There's very few against public company directors. Why is that the case? That's an interesting question on its own, particularly given the fact that you've got quite a few actions in Australia against public company directors. Some might say that's because the regulator's got a particular an attempt to try and stamp its authority. So yeah, some of the things are really interesting. We have to make that distinction when we look at particular actions. But we were trying to look at it rather neutrally, just as possible liability. The fact is that I think with private company directors, there's more likelihood of an action being brought against them for a number of reasons. One being that they probably don't get the same legal advice as a public company director does, either in the company or outside of the company.
I think we should draw this formal session to a close, but thank you for a fascinating presentation.